Let's get started. I don't know how you quiet this crowd down there. They just want to talk. Those of you stragglers, come on in and let's go ahead and get started. We got one more where the marathon's almost over for the afternoon. But I do hope you come back tonight. Judge Donald is an extremely impressive woman, judge. She's receiving an award tonight from the judicial section. We also have another award being awarded tonight from the women in law section. So I'm going to talk more about dinner after Mr. Bledsoe is done, but come back after dinner because it's going to be great. It'll be just like last night. So I'm going to turn this over to Pace McConkey. As those of you who went to his session know, he is a civil rights litigator. He and Gary know each other, and so he's going to introduce Gary, and then we'll go from there.
Thank you, Steve, and once again I commend you and all of the organizers of this conference, which has been phenomenal and will continue to be. And it's a great privilege to be here. I'm Pace McConkey, Director of the Robert M. Bell Center for Civil Rights and Education at Morgan State University. Many years ago, when I was a very young lawyer with the legal department of the NAACP at its national headquarters in Baltimore, I was at a press conference with Dr. Benjamin L. Hooks, who was president and CEO of the NAACP at the time. And I'll never forget at this press conference, as he was addressing some initiatives of the NAACP in light of current events at the time. He took questions, and someone in the press asked Dr. Hooks, who is an esteemed and fiery Baptist minister from Memphis, Dr. Hooks, when is the NAACP going to stop marching and protesting? I mean, aren't we there yet? Haven't we accomplished what we need to accomplish in race discrimination? When are you going to stop marching and protesting? And Ben Hooks laughed, and he said, "We'll be doing this till Jesus comes, and then some." It was about that time that I also met another young lawyer in Austin, Texas, Gary Bledsoe, who was an attorney, I believe, at the time with the Attorney General's office in Texas. But he had also just been named the president of the Texas State Conference of the NAACP. That was 1991. But with our first meeting in Austin, it didn't take long for me to recognize what type of a person it required to be the leader of the NAACP, the voice for civil rights and racial justice in Texas. I mean, no offense, but think about that. To be the leader of the NAACP and the voice for civil rights and racial justice in Texas. That was 32 years ago, and Gary is still president of the Texas State Conference of the NAACP. And it's been my distinct privilege to associate with him and to personally witness the strength of his character and the capacity of his leadership over those 32 years. And I don't hesitate to say that I stand in awe of him in many ways, and with the utmost respect, appreciation, and esteem. Gary has since been named to the National Board of Directors of the NAACP. He has had so many accomplishments with and through the NAACP. He's also been named to the Texas Southern University Board of Regents, where he served for, I think, over 10 years. He was interim dean of the Thurgood Marshall School of Law at Texas Southern University, member of the Texas ACLU Board of Directors, among many, many other positions, titles, and opportunities to serve and influence and make a difference. But really, it's his ties with the NAACP, plus his personal life and his legal practice, all considered together, that reveals the whole man that is Gary Bledsoe. He's all in. He is fully committed. There is nothing in Gary Bledsoe that is not dedicated to civil rights, racial justice, and human dignity. He lives it, he breathes it, he eats it, he drinks it. Gary Bledsoe has done more in his sleep for civil rights and racial justice than most of us do in our waking hours. And his legal practice reflects that, where he has been so involved as a public interest lawyer in civil rights and racial justice law, winning impactful litigation in employment law, voting rights, redistricting, school desegregation, police department reform, criminal justice reform, retaliation in employment, just to name a few. So when I consider Gary Bledsoe's work and his life, and that earlier statement that Dr. Ben Hooks made in that press conference, he's right. Ben Hooks was exactly right. And we will continue to educate, agitate, litigate, and legislate for as long as it takes. We will rise up in the moment. We will face the wind and march forward with steadfastness, unyielding. We will tear down that which needs to be torn down, and we will build up that which needs to be built up. We will stand on the shoulders of giants who came before us and allowed us vision to see. We will prepare the way for those who will come after us, knowing that it is not ours to finish this work, but we cannot neglect doing what we must do in the time that is given us to do it. We will honor the sacrifices already made. We will bear the cross every day that we have breath. We will carry the torch and pass it to a new generation, and we will do it until Jesus comes. And we'll do it through the millennium, and it will be said of us that we refuse to be tired, that we would not be turned around, that we would never be complacent or complicit, that our voices would not be silent, and that we would not stop until justice runs down like waters and righteousness like a mighty stream. And I know exactly who I will stand with in this work and precisely who I will keep doing it with. Who, among all the lawyers in the world, who among all the advocates, I know exactly who I will be standing with today, tomorrow, and on Judgment Day. My friend and my brother, Gary Bledsoe.
I'm a little embarrassed by that introduction. I mean, we're great friends, and what I've always told Pace, you're one of the best human beings I've ever met. There's not a bad bone in your body. And my wife feels the same way. He's been a good and close friend for many, many years. And as I was telling some of the law students at lunch this man is a great example of what you want to do with your legal career. Because maybe you don't eat as well as some others, but you eat well enough. But the mark that you leave in life and the people that you help really makes a difference. And to me, and I think to Pace, that's our Super Bowl. That's our big check. Every time we see someone who walks out with justice, somebody that has a job or an opportunity, someone who has gotten relief from someone who has done them wrong, that just makes you feel good inside. And I think that's why we want to continue to build up our legal community. And so we need to have more great warriors like Pace, because I know that he and I aren't as young as we were back in 1991. And so I'm so glad to see that there are young people here today. And when Steve reached out to me and we discussed what I might want to talk about, there's been something that's really just been burning me, and I don't know if any of you followed any of the press that's occurring in Texas, but it's really kind of symptomatic of what's occurring in the country. And that is, we really have a revolution going on around us, my friends. And one thing I believe is that everyone in this room loves this country, that everyone in this country who loves this country would want to see it survive and thrive. And so I think there's a call to action that I want to bring to you today that I think is going to be important to all of us. And it doesn't matter whether you're liberal or moderate or conservative. It really doesn't matter, because I think if you cherish the Constitution and what it stands for, then we can all stand together, because I think what we want to see is things to continue. I think it's good to have a debate. I'm wrong sometimes. I know. I don't like to admit it, but I know that I'm wrong. We're all wrong sometimes. But I like to advance my interests, and I like to hear the other side as well. And I think when we look at the title here, the Rumpelstiltskin, that's one thing Martin Luther King talked about a lot. Rumpelstiltskin, when he was trying to awaken America, because he saw what was occurring in America, and he wanted people to understand and to be part of the solution. So what am I talking about in terms of what's actually occurring today? I think we see a lot of issues before the Supreme Court, a lot of matters that are related to those issues, seeking to change and modify what the law of the land is in this country and how each one of us lives. Those things are going to be made, those decisions are going to be made very soon. And they hopefully will not be made in the context of politics, because that's not good law. When you make decisions in the context of politics, it makes for a bad situation for the future. So and as what I mentioned, and I know that Pace mentioned it earlier when he spoke, it's about becoming social engineers. And a social engineer is not limited to the issue of race. And so I want to be very clear on that. We want this country to be better in all ways possible. And the legal community can really be a major part of that. The legal community has had so much to do with what's occurred in this country, good and bad. We go back, we look at Dred Scott v. Sanford. And at Dred Scott v. Sanford, they said people who look like me could never be citizens of this country. They not only said you weren't citizens, they said you could not be. Even if you were matriculated, even if you were not in bondage and you lived in the North, they said you, because of the color of your skin, could never become a citizen in this country. And then we had Plessy. And so after you pass the 14th Amendment and you make persons who look like me into citizens, there's another impediment, and it says that we're not equal citizens. We are separate but equal citizens. We have to go to different places of public accommodation and what have you. So we're still fighting to get in. But what is it? It's the law that tells us this. And one of the ironies is, in those cases in the late 1880s and 1890s, that many of those judges were Republican judges that made those decisions. And at that time, the Republican Party was the party of Lincoln, was the party that was supported by persons of African descent in the United States of America. And so then we go all the way up to Korematsu, right? And Korematsu says that even after you are a citizen, it doesn't really matter. We can take your citizenship, we can take you and lock you up, even though you haven't done anything wrong, without proof. The only thing that matters is you have Japanese ancestry. And Korematsu has never been overruled or overturned. So theoretically, Korematsu could happen again tomorrow. And so that's a real problem in terms of looking at decisions that are really problematic or harmful. But it's the law that did that. And then we have Smith versus Allwright. And what does Smith say? Smith said that you can't prevent persons of African descent from voting, but of course that hasn't really occurred. That's why we had to have the 65 Voting Rights Act. And ultimately, going down to Shelby County that you see there, we know that that big hole has been driven in that. But it's the law that's driving all of these decisions. Now Allwright and Brown v. Board and Oberfeld are all decisions that are decisions that I personally like, but I think that maybe there's some that do not. But I think those were just decisions. And Citizens United is one that kind of tips the scales, and it means that regular people will no longer have the influence that they should have. And I want to talk about the preamble a little later. But the preamble starts out with what words? We the people, okay? We the people. It wasn't talking about corporations. Oh, they weren't talking about corporations. But in Citizens United, they said that corporations are people, and they can put funds, and just like everybody else, into campaigns, and that has really kind of upset the apple cart in this country, and it's frozen out a number of voices. And it's not just about Republicans and Democrats, because there are voices within either of those parties that are frozen out because of this whole idea with Citizens United. So all those are really issues that it's up to the legal community. And see, what happens when these cases go to the Supreme Court is they'll hear from people like me, like Pace, and they'll hear from people who are more conservative on the other side. They don't hear from the masses in the legal community. That's what's missing. You know, I'm fighting a battle in Texas. We're fighting, you know, our governor has just come out and decided to outlaw all DEI programs just at a whim. No basis, just saying they're unconstitutional. There's no basis for it, and we've called his hand, and we're debating him on that every day. There's even an article in the Houston Chronicle today talking about it. But he did that. But what we need is we need voices from other places to be part of the discussion, because sometimes things are just clear. And that's what's missing here, because I think once the people in the legal community come aboard, and some things just are for good common sense, I think we can have a whole different situation. Now, on the issues that I work and am concerned about, you know, the FBI has come out and they did get some attention on this. I've met with a number of FBI officials, even the heads of the FBI, and to discuss this, because people who look like me and who do the work that I do are really kind of under threat all the time. And we have people, some of our branch presidents in Texas, that have to have daily police protection because of issues that they've encountered. And many of us, including me, have had threats and even had Klan personnel prosecuted for directing harm or threats towards us. And so that's real. That's going on in the country now. What did the FBI say? The number one threat to us domestically from terrorism comes from white supremacists or white separatists. Now, And I think that's really significant, but you don't see that law enforcement has addressed that effectively for various reasons. And so I think that's even spilled over to the next matter about January 6th and the counter-narrative that we're seeing and about to see even more of. Because the concern I have is this with January 6th. I think many of us have seen what many people have done and were accused of doing. It's on videotape. There have been jury trials, there have been convictions, there have been pleas of guilty. But we still have this counter-narrative that's going on out there. And the threat with the counter-narrative is this. With the counter-narrative, once you allow counter-narrative and something like January 6th happens, it can happen again. And because what you need to know, we have a lawsuit, and I don't mean to be political here, but I'll just say the NAACP National has a lawsuit against the former president. And it is because of our belief, which apparently the Justice Department apparently decided yesterday that they share, that the actions of the former president and those working with him actually were to prevent Congress from exercising its constitutional duty in terms of certifying the previous election. And there's a law that was put in place, the Ku Klux Klan Act, back because of the emancipation of the slaves back in 1872, that said you cannot do that. That if you try to intimidate any federal official in the exercise of their official duty, then you can be prosecuted under the law. And apparently they're going to file a civil suit under that, which is what the NAA did. But that's going on today, because if you allow people to interrupt Congress and prevent Congress from exercising its duty, what's going to happen in 2024? What's going to happen in 2028? If you're going to have a country, you got to make sure that those kind of things don't happen. But the legal community needs to be heard from, conservative, moderate, and liberal. There have been many great voices, even on the right there, but I don't know if they've had the effect that they can have. You know, the opinion polls show there's such distrust in this country, and people dislike each other more and more. And we see that even here, Marjorie Taylor Greene from Georgia, right here, is saying that the nation should divorce, that we should split from red and blue. And that's truly problematic if we understand what the consequences might be with that. And so we're disregarding some of the things that really are out there. I read that report that the Senate Intelligence Committee with Richard Burr that they did in reference to the issue of Russian interference in the 2016 elections. And it was pretty clear. And one thing that grabbed me, that I think the press, I've seen a couple of articles in the Washington Post about it, but I haven't seen enough copy about it. One thing that grabbed me was that it talked about race, how what they understood, the Russians who were trolling the internet and the strategies they put together, they realized the way they could get to this nation and this country was to really try to put a wedge on the race issue and actually stoke the flames of the racial divide. And we see that's occurring more and more now. It's even more so than it was in 2016. It's continued to occur. But that's an Achilles heel, that people who are maybe not supporters of this country will know that that actually exists, and that is a vulnerability for this country. And, you know, we look at the debates here. I encourage everyone to look at the South Lake podcast because that really shows it's really about an affluent district, primarily a Republican district with good folks. And what we found is that probably over 100 white parents showed up to complain about white students using the N-word against black students. And they were saying, we don't want our children to be raised that way. So the school board decided they were going to do something about it. And the school board put together this huge task force for all these people that used to play with the Dallas Cowboys or the Dallas Mavericks or CEOs of major corporations in the Dallas-Fort Worth area. And they came up with a very modest policy. And what happens is the right-wing guys filed a lawsuit, got an injunction. The modest plan never went into effect. They ran an election with the a race-based campaign, and they kicked out the people in office, and so the people who didn't want to see the plan implemented were actually elected. That's actually occurring in Texas right now. And so that's just a kind of a microcosm for what's going on in the country. And so I think we need to be aware and alerted to all those things. But the whole debate about critical race theory, which is nothing about except criminalizing the teaching of African American history, is what that reduces itself to. You know, to sit there and watch a debate and watch senators say that it doesn't matter what the truth is, we don't want any white student to feel bad about what any white person did in the past, is really just outrageous. But that's what the debate was. That's what they said during the debate. I was really shocked and aghast, but that's picked up more and more. And what you find is that extremists have determined that this is good fodder. When you go and you find what the Steve Bannons of the world say it can be used to be a wedge or to get white voters to stoke the flames and to be excited, that's one of those issues. And so they're working school boards and all those kinds of matters. And that's the whole issue with affirmative action, which has never been truthful. I know that that's what one of the big cases that Pace litigated was really about the systemic discrimination against African Americans there in Maryland, and that's really been the truth pretty much all around the country. And you know, the whole DEI thing with the governor to have a broad sweep and all these DEI programs that are modest that were put together by the high dollar law firms that have outstanding lawyers and legal departments at places like the University of Texas, and they would never put together anything that would be the extreme or what have you, but to come out and say they're all bad and issue a memo telling all state agencies and all state colleges and universities that you have to shut down any such program that you have, I think is outrageous. So we're impending for a really big battle there. So I think the law is what's important. And so that's where we come in, being the architects and the people that we want to be and make the society, because all of us have a vision, right? And all of us can see things that could be better in this society, in this world. I can see them. I know you guys can see them. And we may not be the same, but I know what you can see is better than what exists now. And I think many ways. And so I think we shouldn't really be limited. You know, and so when one time Martin Luther King was being questioned by the media, and they were saying, now they were saying, Dr. King, you can't legislate and make people love you. And he said, well, that's true. I really can't make people love me, but you know, I can make it to where they can't lynch me, and I think that's pretty important too. So you know, I think that's one thing that we can do with legislation. We can't legislate and make people love each other, but we can legislate and make for a better law, make for a better system, and that's where we come in. And you know, Dr. King said two things about the church, because I mean, I love that. That's one thing here, Steve, that I truly love, the idea of merging Scripture, merging Scripture with the law, because I think that's extremely important to do that and to have a noble practice of law. But Dr. King said there were two things that the church did primarily. One was it was to deepen one's faith in God, because that would do things that would be really important for the individual on so many fronts, including when difficult times would come. You know, for example, having faith in God is one thing that it's always been felt that helped African Americans get through slavery. I mean, many folks don't know, but the old spirituals that you saw people singing were in part designed to lift them up so they could get through the difficult conditions they were in. But the other thing that was really interesting about them is that they were roadmaps to the Underground Railroad. If you haven't been to the Slavery Museum in Cincinnati, Ohio, I encourage you to do it because it's pretty fascinating. They have a number of the spirituals that have been put to video or film that have been narrated by Oprah Winfrey, and I think it's pretty illuminating and fascinating about what that was and how the direction was being seen and how they were identifying people for you to go and see in different locations. So I think it was truly wonderful. So I'm saying, why not the legal community? Why is it we've got to be confined? You know, when I see lawyers argue, we're always talking about what? What's the precedent? And so, but what we all know is that precedent makes for bad decisions sometimes, right? Because personally, I'm glad that Dred Scott is overturned, okay? Personally, I'm glad that Plessy versus Ferguson is no longer the law. So I'm not married to say that every decision that's been made in the past is a righteous decision, okay? But that's kind of where we are, and we're there arguing about what case said this and what case said that, and that's important, and we should do that, okay? But I think there's something additional to it, and I'm talking about expanding the justice that we can obtain within the judiciary, not be blinded or limited to just that simple thing of talking about whatever precedent is. So why can't the legal community do what Dr. King says? Because the second thing Dr. King says that the church does is it's supposed to eliminate all those horrible beliefs and thoughts that you have. He was very critical of the white church because he said that there were all these folks that had bigoted beliefs and who had such terrible thoughts about individuals that their churches had an obligation to extricate that from them, that they had an obligation to teach them what the right way is for people to treat each other. And so I'm saying, why not the legal community? Why can't we do the same thing? So this is kind of the central focus of what I want to talk about today, because the preamble to the United States Constitution. And when you go back and read the preamble, that's what starts the United States Constitution. And I think in many ways it's probably been forgotten. It's been discussed and mentioned in some Supreme Court cases. I'll talk about one in a bit. But these words here can help revolutionize the practice of law, especially the law that affects people in their everyday lives and the things that we do. Because it first starts out by saying what? We the people. So I think that makes one thing very clear, that it's not about the government, it's about the people. And when they used the term we the people, they didn't mean corporations. They were talking about the people who got together, who understood the horrors of being under the British Crown at that time, and they came up with this document. And it starts out with we the people, in order to form a more perfect union. So that tells me that the idea is to have a more perfect union. And there's a debate in the legal community, even on the Supreme Court. Is the Constitution static or is it living? Okay, I think this suggests to me that it's clearly a living document. That the founders understood that they had the wisdom and the knowledge to know they didn't know everything, and that this was meant to be formulated to go from time to time to make for a proper situation. Now the next one is the big one. It says establish justice. Establish justice. I know when I was at Thurgood Marshall, I went to invited Judge Gregory, the chief judge in the 11th Circuit, and he came to speak, and he made this comment that has always stuck with me there. He didn't understand why more lawyers didn't use that and cite that in arguments or briefs before the court. And I thought, wow, that's really kind of significant. I would agree with that. That established justice, and later I've got a law review article that I cited that discusses his jurisprudence. And in that law review article, they talk about there's one case in particular that kind of illuminates what I'm talking about here and why I'm saying I think it can apply in everyone's practice. there was a case where the United States attorney agreed that this person, it was wrong and excessive to give them life in prison. And the defense counsel and the defendant thought it was wrong to give him life in prison. The trial judge had a mistaken belief or understanding of the law, and it thought that the trial judge could only give him the punishment of life in prison. And so everyone understood that, that because of all the circumstances and his limited responsibility in the crime, he should not get anywhere near life imprisonment. And so, but the court held, the 11th Circuit, that their hands were tied. No one decided and no one debated that he didn't deserve life in prison. But because they said, well, this judge did it, and therefore, since this judge did it, there's no way under the law that's been written that we can change it, so we're going to let this man sit there in prison for life. And Judge Gregory dissented from that opinion, because he said, look, everyone here is looking, said this is wrong. And so how many of us can think of situations like that, right? Where we say, well, this is the written term of the law, and so literally this is what the words say, so therefore we can't have any kind of flexibility here. But I think if you look at the law review article that I cite and maybe go and read that decision, it's really kind of illuminating on how one can maybe use this whole idea of bringing justice into your practice. But it goes on further to talk about ensuring domestic tranquility. You know, I think that one thing I want to make clear in my mind is that it's not inconsistent that you can have order and freedom. It's not inconsistent to have order and freedom, because we cherish the freedom. That's what this document was meant to do, is to give individuals within this country freedoms. But at the same time, what the founders understood is you needed to have common sense. We don't need to do things that are going to undermine us and allow someone to come in here and unravel this country. No, so I know I'm sounding like I'm more on the right wing now, but I'm saying, but that's really common sense. And what this document says is provide for the common defense, promote the general welfare, okay, and secure the blessing of liberty to ourselves and our posterity. So what they're saying, I think they understood that posterity and opportunity were important for people to buy into the country, to understand that this country is ours, that some people maybe don't have means or what have you, but we want everybody to buy into this country. This is a well thought out preamble. This preamble is really brilliant because it's talking about defense, so we don't allow anyone, whether it's hate groups in this country, to hide behind some kind of law or legal maneuver and be able to organize and do things to destroy parts of this country, if not the country itself. So there's a balance, but we have to have common sense with liberty. But I think this allows us to do just that. So when I look at when I look at this, I think that I can understand what people like Judge Gregory are talking about, because I think really indeed that justice is something we should be talking about, because justice is really important in every case. How many times have you seen cases, for example, whether it's in a probate case and someone gets nothing and they should get more, or whether it's a case with an injury and you don't, someone doesn't get anything, or they get a lot less than they should. You know, we already do something like this, so it's not as revolutionary as people think that it is. For example, if you win a large verdict and you get that large verdict changed or modified by an appellate court, what are they doing? They're doing it in the interest of the corporation or whatever that was sued, saying that this amount is too high. So I'm not talking about something that's truly radical. I'm talking about something that would be very unique, but something that we really ought consider. It's the kind of thing that maybe has been done in some ways in school deseg cases. You know, that's not different from having someone proceed in equity to try to modify what was possible in law. I'm just saying that we shouldn't be blind to justice and look at something and always say, and so we just go on and we further. What we have is probably a superior legal system to most others around the world, but I don't know that we have a perfect legal system. But I think this kind of idea, this kind of thinking can make us have an even better legal system. Now that Jacobson v. Massachusetts, you know, that was a case that really discussed the preamble, and one of the great jurists, you know, Justice Harlan, was writing in that case, and this is where he talked about what the preamble actually means, and he acknowledges it doesn't provide substantive law, so we can't file a brief and say I'm suing, file a lawsuit, I'm suing under the preamble. But the preamble is a guide. It's a guide in a lot of different ways. It can be a guide to interpreting a provision of the Constitution. It can be a guide in interpreting a statute. It can be an argument as to what a judge's action should be, an exercise of their authority. So I think that we look at this, and what he did, and the opinion, he cited Chief Justice Marshall. And he cited Chief Justice Marshall saying that you should follow the spirit of the law just as you should the text of the law. And I think that's really important that Chief Justice Marshall did that. And I'll make another statement that's maybe a little bit controversial, maybe in a way. I think Marbury versus Madison was that kind of decision. I think Marbury was a common sense decision, where Marshall said, how is this country going to survive? What do we need about the play and the interchange between the different branches of government so that we don't go the way of what's happened in the past? He was looking at the common sense from the preamble and making the decision, Marbury versus Madison. So I don't think it's really a bad thing at all to consider that. You know, those words are put there at the beginning of the Constitution for a reason, because they're at the beginning of the Constitution. And I put these here just because I think you can, I want to show some of the decisions that were made and how these things might play in everyday life. You take that first case. That first case involved the situation where they decided it was a way of probably trying to get game wardens that were unfit, but that obviously had an impact on people based on age. And so the court said the only way you can do this is to have something that's individualized, that it must be, you can't make a gross assertion and get the whole group, kind of like the governor's doing in Texas. You know, all DEI programs have to be shut down. You can't do any more DEI programs without any allusion to any specific problem in any one program. This makes the broad sweeping statement. But they said you need to make individualized assessments before you take action. And so you go to that next opinion, Duncan versus Kahanamoku. And that case was decided different from Korematsu. But that was 1946. And so we understand the difference. And that goes to the point about sometimes decisions are made in a bad law, and judges are human beings and things like that. And so this decision comes out differently. Why couldn't Korematsu come out that way? You know, because in Korematsu, what the court decided was there was no way to intelligently make a quick decision about which persons of Japanese ancestry should be locked up and which ones shouldn't, so we just have to put them all there. I think that's outrageous to me, and that's a real problem. This is the way really that it really should be done. If you're going to be fair to individuals, you need to have some feeling that some individual presents a threat. There's another law review article too about Judge Gregory that I want to mention later. You know, the idea with Charles Hamilton Houston is really significant because he was trying to understand how to change this country. And so I think when you study and understand Charles Hamilton Houston, you really kind of know the brilliance that one can see, where you can put together a strategy, and that strategy can really lead to big change. Because when Charles Hamilton Houston started working with the NAACP and doing the legal work of the NAACP, he realized that something you couldn't change overnight. What many people don't know is that when his first case that he argued before the United States Supreme Court, one of the justices was so racist that when he got up to argue, he turned and watched the back wall during the whole time that he argued. The whole time that he argued, the justice refused to look at it. He was the same judge that refused to take photographs with the court because there were Jewish members of the court, and he was anti-Semitic as well. But what he understood was that this court will change. We can change this country. So the first 15 or so years of litigating those cases, between 15 and 20 years, they simply tried to enforce Plessy versus Ferguson because they knew that things weren't separate but equal. They had, it was a big decision, and they had serious arguments between all the legal minds with the NAACP about whether or not to attack the separate but equal doctrine under Plessy versus Ferguson. But he knew how to change the country, and he worked to change the country, and he had good people that he would look to, like Justice Frankfurter on the Supreme Court. And by the way, there's a recent book about Justice Frankfurter, and I would encourage you to look at that book. The book has a great discussion in it about the court in Korematsu, because what you found is that you had a number of people that were even Roosevelt appointees, progressive judges or what have you, that because of the circumstances went the wrong way. And so I think those things need to be a testament of a real concern about what happens under bad times or bad circumstances. But social engineering, I'm saying, we got all kinds of areas that we can make better. We see stupid decisions all the time relating to the welfare of a child, who can have access to a child, who can't have access to a child, the funding of student education, the foster care, LGBTQ children, and how they're treated within the school systems. We're fighting some battles in Texas, the NAA right now, where the number of white students just decided to call black students the N-word. One was in Slayton, Texas, and the young African-American female was the highest-ranking senior in her class, was scheduled to be the valedictorian. And she wouldn't complain, and the school district didn't do anything, so she continued to complain. So they ended up putting her in alternative school, and she attempted to commit suicide last December. But thank goodness she did not succeed, but now she's in a charter school. That's a real tragedy, but all she did was saying, I want to have dignity. I'm the valedictorian of this class, and they're going to be calling me the N-word every day, and you guys won't help me? You won't discipline these students? You won't tell them not to do it? It's outrageous, but that's really where we are. The preamble, again, says we're intended to be a living document. But what I want to say, because I know that I kind of have a bent, I'm a bit to the left, not as far left as some people may think, but it's not, my argument about using the preamble is not right, left, or what have you. It could be clearly the middle, because what I'm saying is this, in essence, that when you require a judge to assess what is just in a case, that allows other things to come in. That allows everyone's concern, all stakeholders, their interests are then considered. Because in most cases, that's not the case. You look at the text of a statute or whatever, or something, you don't look at the stakeholders. You don't look at the multiple interests that might be involved in an individual case. But when you go to justice, you look at every single issue. You know, like on immigration, it's not as simple issue as what some people say. You know, on the far right, they say let no one in or let no one in except whites in from various white countries in Europe. And then you have the far left saying let everybody in, that they interpret literally what's on the Statue of Liberty. And then you have people in the middle say, well, look, we got to be, we want to help, we want to be part of the solution. Let's come up with the proper and effective means, but they're kind of ensnared in the middle. And even on Roe, you know, I think people think Roe is on the left. Roe is not really on the left, because there are many people that are critical of Roe as actually putting limits on a woman's right to choose, saying that the government should have no interest. So that's really the left there. And the right obviously saying it doesn't matter if it's the life of the mother. Roe is kind of in the middle. I know it's been put out there as on the left, but I put it as center left. But you have to take all the interests that are involved. There's an interest of an unborn child. There's an interest of the mother. There's a whole lot of interest. There's an interest of a father. There's an interest of a family. But you take them all in. I'm not saying what the solution is, but you take all of them in. But I think that Roe has been misrepresented, because Roe is really a modest decision. So, and I look at what's at the Supreme Court now, and I think this also goes to the idea of democracy and what democracy means, and this whole debate over 230. And the issue is this: can you shield yourself behind this 230 immunity, even though you actually take an affirmative act and affirmative step? You know, and the one step, the allegation is that by putting the algorithm together and putting people together that are hate mongers, that this led to that bombing in Paris. And the second case that involved a young 10-year-old girl that took a blackout challenge that she would not have known but for the algorithm sending it to her. And so she did the blackout challenge, and she ended up killing herself. And so so families are suing in both those situations, in both those cases. But there are a lot of interests that are involved. Is it simply that you say there's immunity, and that's all that matters, that once you say there's immunity, it's all done? Or is there some standard or obligation that you have to have in order to have that immunity? Or do you not have that immunity? Immunity that's written, the literal term of the immunity is for third-party postings. Third-party postings. But what we have in those cases is not third-party postings. We had in those two cases were actual algorithms that sent information to people that were at issue, so you took an affirmative step, and you're saying that that's the only way to make it where people can use it effectively. I would totally disagree with that myself. That's my own bias. I'll be honest, I've got a bias, but that's not the same thing as a third-party posting. You're taking an algorithm and you're making people meet. You're making hate mongers meet. You're having hate mongers be able to meet and put together things that are going to go and harm people. And I think you don't, and just because the hate mongers come to your site and then you put them together, but therefore, but you're innocent for anything that they do, even though you're the one that put them together. I think that kind of defies logic in my mind. But that's where, when you look at justice, what is justice? What are the other interests that are involved? Not just trying to look at the text of 230 and what was meant by 230. You know, I saw where the co-sponsors, the Republican Democratic co-sponsors, sent their own brief to the court saying that it was intended to cover this type of situation. Maybe it was, but I don't think that's the equitable or the just thing to do. But I think decisions like this, because if we allow that to happen, and there's nowhere in the world Congress is probably going to change that, then what we're saying is we're legally allowing people to organize hate and to put together movements to go and destroy cities, destroy counties and neighborhoods, that we're legally going to allow them to do that, and we're going to allow these large companies to put them together and allow them to do it. And so we're going to sit there blindly like Rumpelstiltskin and see this going on and allow that to happen in our areas while we know it. We know if you require them to fix it, you prevent them from putting people together, they won't put them together. And I know it doesn't sound like someone who's on the ACLU board or who feels that he's really a civil libertarian, but I think there is always a line. There's always a line. And I think that would be a foolish line to draw to allow that. And I'll say this, it's kind of interesting because, the industry can't win in a way. The right says there's overregulation, and we say, NAACP and other groups, that there's not enough regulation because what's happened is all this hate traffic that occurs. It's allowing these hate groups to get together and to do horrible things, and we see evidence of that. The Anti-Defamation League has been really big on that, besides the NAACP, but a number of other organizations too. It's too much regulation, one side, and we say is not enough regulation. But I look at those hearings before Congress, and I don't see any hope, to be very honest with you. I think those companies are so large and in charge that I don't see people on the left or the right having enough of a consensus to move anything on those. Now, get to the issue that's close to my heart in terms of another issue where we need others to stand in and to stand up and to be with us, because in front of our very eyes, this is part of the revolution that's going on. We see in Georgia and Texas and other places, there's extreme laws that are outrageous. There are laws that probably deserve to be in the 20s or 30s, but not today. And I think if you read the text of the laws, you can see where these laws are outrageous. They're extreme. They're intended to deny people the right and opportunity to be able to vote. They're changing everything. They're changing the eligibility to vote. They're making it easier to purge individuals. They're making it harder to sustain your own vote. If you miss an election or two, they can easily purge you without regard to why you may have missed one or two elections. They're trying to make it hard for older people to vote. I was shocked, but this week a senator in Texas introduced a bill that prevented people 65 and over from being able to automatically get a mail-in ballot if they request them now. So they're actually attacking old people because old people tend to vote the other way, and so therefore they're going after older folks as well. They changed the law. We won a victory in front of the Texas Supreme Court before it went the way of the Attorney General back in 2020. During that election, we won a big victory where the all-Republican Texas Supreme Court held that people had a reasonable belief of issues with COVID that had underlying conditions or concerns, had a legitimate right to request a mail-in ballot. And that was just a very good decision. The Democratic Party wanted there to be no limits, that anybody should request it, and the Republican Party said no one should be able to request it. But the court went with us. And what happens? They change the law when the legislature comes around to make it more difficult. So you can't have that kind of a reasonable decision. That's what I'm talking about with power. But you see that kind of revolution that's occurring right in front of you. So when we won that opinion and that decision, and they just changed the law. So what they're trying to do is make 40 greater than 60. And I talk about Texas not just because I'm from Texas, but that's a microcosm of what's actually occurring in this country. And I think it's important for me to note that. See, what's occurring in Texas is I could see back in the 2010 census said Texas was 49.4% African American and Latino combined. And I think that's it's adult population. And people were saying, my gosh, this is fearful. The white population was 45%. The others made up the difference. Right now, in this last 2020 census, Texas is now 59% minority and 41% Anglo. So, but instead of saying, oh, look, we've seen that we work together all around these places. We have different people on city councils and all that. There's schizophrenia that's occurred in our state. And so therefore they're passing all these incredible laws so that you can make sure that 40 is greater than 60. And how do you make sure that 40 is greater than 60? Well, you purge the rolls, you make it more difficult to vote, you increase the penalties if you make a mistake on your voting card. You come up with technicalities like if you registered like I did 40 years ago and you request a mail-in ballot, I've got to use the same form of ID I did 40 years ago. And I don't remember what form of ID I used. But that kind of draconian requirement that's in the law will limit that. And we've had a real problem, for example, with racist poll watchers. And they're doing it here in Georgia now. A real problem. The same group in Texas have now been employed and imported over to Georgia. And they go and terrorize minority neighborhoods. And they made it to where there were, let me give you one great example. We had terrorizing poll watchers actually going to minority neighborhoods and during the pandemic and refusing to wear masks. And they would get up in the space of black and brown voters. They wouldn't get up in the space of white voters, but they would watch the black and brown voters and be very close to them, make them uncomfortable because of COVID, not just the sensitivity of their ballots. And so there were a number of African-American female election judges who kicked them out. And that became a big issue. So the legislature changed the balance and made the poll watchers more powerful than the election judge. So the election judge can bother anybody in their polling place except a poll watcher. And so you do things like that, you're sending a signal out there, we don't want people to vote. And they're making, and I testified on a bill this week, I testified on a bill Monday, where what they're doing, they're making, there's Crystal Mason, a young lady who made a mistake in voting. She had a felony conviction. And with her felony conviction, she'd been she was on probation, she was released, and she'd been paroled, I guess. And so she thought she could vote. She told the probation officer. She went and registered to vote, and she cast a ballot. But they wouldn't take it as a real ballot. So it was one of those conditional ballots that was never counted. Okay, and so she got indicted and ended up getting, I think, 8 years in prison for doing that, which is ironic to do that because she was on probation. She got 8 years in prison, and so but that kind of mistake in Texas of making a mistake in voting was a misdemeanor, and so what they've done this session, two things. They've taken away a mens rea requirement in the law because the Court of Criminal Appeals, all Republican court, has decided that what occurred in her case is outrageous and you need to have some finding that she understood that was wrong. And so there's the bill now, which passed out of the Senate this week, of the Senate committee, it's supported by our lieutenant governor, says you don't have mens rea. And all of us who went to law school, we understand the importance of mens rea. Can you think of not requiring mens rea in a crime like that, especially in the sense that they increased the penalty to a second-degree felony, which means you can do 20 years in prison for that. Now, the penalty for kidnapping in Texas, where you endanger the life of a child, is a third-degree felony, up to 10 years in prison. So they're going to make that technicality of a Crystal Mason 20 years imprisonment. So you see those kind of things that are happening in our very eyes. So I'm speaking, other minority groups are speaking, people that maybe are white Democratic officials are speaking. But we need to have other groups, and people say, that's outrageous, because people don't listen to me, right? I mean, various people may listen to me, but there are people, some people turn on the television, they'll see it's me, and they'll turn the channel, right? We need to be getting into homes of people to really make a difference, because when you get one group that's large and in charge, they'll just make bad decisions, because power is inherently corrupt, right? And so that's a problem if you can't have a check on power. So that's what's going on in the voting thing, but it's going on all around the country, because all around the country they're passing these voting laws now to take people out of the voting place. And one of the reasons why we have voting laws is that you look at like what Thomas Friedman talked about, and why you provide opportunity, and why you have things like Social Security. You want people to buy into the system. You want everybody to feel like this is their country, okay? And so you want everybody to feel, you may not like how people vote, but you need to allow people to vote. And so I think it just makes the country a lot stronger. But we've got all these cases coming up, and there seems to be a real chance we're going to have decisions made in a political vacuum. What I'm saying is that when you guys come out, when different folks who maybe don't look like me, different organizations, different lawyers, and you speak out, it becomes something very different. It becomes something that's against the interests of this country. And because we don't want these things to be made in a political vacuum. What people think and feel is that, well, we got 6 on one side and 3 on the other, so we win all cases over here. We have 6. We've got to be able to somehow reach and get things that are best for the country. Sometimes the right will win. Sometimes the left will win. Sometimes neither will win. It'll be a different kind of decision. But we're going to need each one of you guys to be in there. And so this poem has always grabbed me, and I think this is what's going on in this country now. You know, this Martin Niemöller, first they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak. Well, today they may be going after black folks and brown folks or others, but tomorrow it might be your neighborhood. And the inability, like, for example, of a very affluent white suburban neighborhood in Texas that passed a law to limit fracking because they were having earthquakes. Let me tell you, they were having earthquakes in their city that all the seismologists and folks said were due to the fracking. And what happened is the oil and gas industry goes to the legislature and gets them to overturn the city's law. So maybe me today, but it's going to be someone else tomorrow. There's got to be a reason why you need to have justice in every single case. And, you know, Pace said this earlier, so he's always still in the thoughts there because we think so much alike. But this old comment from Dr. King, where you're trying to merge the law with religion, you know, and the whole idea is what we're seeking. We shouldn't, that he said, we will not be satisfied until justice rolls down like waters and righteousness like a mighty stream. I think that's really what we want. And we shouldn't be limited by saying, okay, in the traditional way, we got precedent here and precedent there, and I don't want the law students to think the wrong thing on that, but I think precedent's important, but I think we need to be looking at new and different areas, trying to expand on what justice is and different ways and avenues of reaching a right decision. And when you have all the different interests that are at play, you can have decisions that are made. And I don't care whether you're involved in commercial litigation, whether you're involved in probate litigation or probate cases, there's a way that this can help you and impact you and your practice. So I encourage everybody to go to the groups that you're in and reach out to them and get them to take a look at this issue. Let's get Brigham Young and others, Mike, to look at it and get scholarship, maybe people to write articles and see if they agree or maybe they disagree. But I think the more scholarship that there is, the more that we have people like Judge Gregory out there talking about the need to try to import justice in every case. The more we have lawyers filing briefs that are talking about this, the more we have lawyers that are making these arguments to enlighten judges as to what they are. And they're creeping up in opinions. You know, when I was doing research, putting this presentation together, I found a number of Court of Appeals cases in Texas. I was shocked. So they're out there. People know about this and understand this, and I just encourage you to join in and to be part of it, and look forward to working with all of you to making forward to us having a great legal community. And what Justice Gregory said is that we are the academy. It's something special to be in the academy. And being the academy, we can make for change. We can make the world a better place by work of the academy. So I charge all of you as brothers and sisters of the academy to join with us in making our country a better country. Thank you very much.
Monarch Law Society has commissioned me, of all people, to give you this gift, and
Oh, thank you.
thanks and appreciation for your willingness to come and address this conference this weekend. Thank you. Let's thank everyone.
I'm honored to be here. Thank you. Thank you. Thank you. Oh, thank you.